Mr. Morley.
Thank you, Chair. So the National Police Chiefs Council has had a limited role in T1, and these closing oral submissions will be brief and to the point. I will address two themes, the MPCC's ongoing role in the inquiry and the MPCC's view on the inquiry's consideration of the applicable legal framework relating to undercover policing. So the first topic, the MPCC's ongoing role. As you know, the MPCC is a coordination body, and its primary purpose is to enable independent chief constables and their forces to work together to deliver an effective police service and to improve policing for the public. The MPCC coordinates the operational response across the wider police service to some of the country's most serious threats, including terrorism, organised crime, and national emergencies. Together with the College of Policing, it seeks also to improve standards and training and promote public confidence in the police service. The MPCC does not act for any individual officer or former officer in this inquiry, whether they be SDS or NPOIU officers. But self-evidently, the individual acts of officers or the behaviour of particular police units reflects on the wider police service. The NPCC is particularly concerned to preserve the utility of undercover policing and its associated tactics and techniques, because of course it is a vital tool in the fight against criminality in all its forms. But preserving the utility of undercover policing does not mean simply preserving the status quo, still less the practices from 50 years ago. And the NPCC wishes to reaffirm its commitment both to this inquiry and to learning the lessons that will inevitably emerge from the inquiry's findings. Sir Christopher noted in his opening remarks back in July 2015 that an important part of the inquiry's function is to make recommendations as to the future deployment of undercover police officers, and the public needs to be assured that when undercover policing is conducted, it takes place under satisfactory statutory and professional conditions. It is in the public interest that any recommendations the inquiry has to make should not be unduly delayed. And it is essential that where any changes do need to be made, these are identified and implemented as quickly as possible, so that the tactic of undercover policing can continue to be used safely and effectively, where appropriate, in the public interest and without causing harm. So the NPCC is keen to ensure that any mistakes which may have been made in the past do not continue into the present or the future. The police service as a whole stands ready to learn from this inquiry's findings, improve the service it provides to the public, and ensure undercover policing is used ethically, appropriately, and effectively. So turning then to the second theme, please, the inquiry's consideration of the applicable legal framework. So far as the legal framework is concerned, the NPCC makes 2 points in its written submissions. Firstly, Section 2 of the Inquiries Act specifically provides that an inquiry may not rule upon or determine civil or criminal liability. Mr. Skelton, KC, and Mr. Sanders, KC, both made this point yesterday, and the NPCC takes the same view. While it is perfectly permissible for the inquiry to identify and comment upon the legal framework for undercover policing as it existed at the relevant time, in our respectful submission, it would not be permissible to go a step further and make findings or rulings that any particular activity was unlawful. A public inquiry is simply not designed to reach findings akin to those that may be made at the conclusion of civil and criminal trials. The proceedings are inquisitorial, not adversarial. There are no statements of case. There's no cross-examination. All participants do not have a free hand in advancing a case or calling witnesses. Common law defences such as consent or public interest are generally fact-specific and not explored. And you, sir, of course, determine what evidence will or will not be called. Accordingly, not only does Section 2 provide that a public inquiry must not rule on civil or criminal liability, because of these limitations, a public inquiry is not well placed to determine civil or criminal liability, and in our respectful submission, it shouldn't. And the second point, so far as the legal framework is concerned, relates to the terms of reference. The inquiry's terms of reference are clear in requiring the chair to identify and assess the adequacy of the justification, authorization, operational governance and oversight of undercover policing, and to identify and assess the adequacy of the statutory policy and judicial regulation of undercover policing. There's no mention of assessing or determining lawfulness in the terms of reference, which, given the wording of Section 2, seems likely to have been a deliberate decision. The terms of reference simply do not require the inquiry to determine lawfulness or legality, and whilst the inquiry is permitted to consider the legal framework in place at the time of the relevant events and identify and assess its adequacy, it must refrain from determining civil or criminal liabilities because the lawfulness of undercover policing simply falls out with the terms of reference. So I conclude by reiterating that undercover policing remains a valuable tool in the armoury of law enforcement, and it continues to be used effectively across the country to prevent and detect crime and to protect the public. Policing has already changed enormously since the SDS operations of the 1970s, and it will continue to evolve and improve. The MPCC stands ready not only to assist this inquiry to the best of its ability, but also to listen and to learn from the inquiry's findings with a view to promoting good practice in undercover policing and ensure improvements in policing continue to be made. So those are my submissions.
Thank you very much. And as you rightly observe, you've come well within the time allowed to you. Grateful to you. Thank you.
Thank you, sir.
We will now adjourn until 10:25 when we will hear from Mr. Sheldon, KC. Thank you. Mr. Sheldon.
Thank you, sir. So thank you very much for allowing us to make these brief oral closing submissions on behalf of the Secretary of State for the Home Department in her capacity as a core participant in your inquiry. As you will have seen, we will not be detaining you very long this morning, which reflects the relatively limited direct involvement of the Home Office in your Tranche 1 investigation. However, we are conscious of the fact that the decision to address modules 2B and 2C on paper, along with the absence of Home Office witnesses in the other Tranche 1 modules, has meant that the opportunities for us, at least, to make oral submissions in the course of your public sessions have been limited. And there are a number of matters that the Home Secretary wishes to place on the public record at this stage in the proceedings, so as to ensure there is a clear understanding of the Home Office's position in respect of both undercover policing in general and the Tranche 1 evidence in particular. As to the former, undercover policing plays a vital role in tackling serious crime and keeping the public safe. However, the Home Secretary recognises the significant concerns about the way in which undercover policing has operated in the past, and it is, of course, for that reason that this inquiry was established in 2015. Having established the inquiry, the Home Secretary is engaging fully with its investigation in order for it to get to the truth of those events and to ensure that lessons are learned for the future. And as you are aware, sir, the Department has undertaken an extensive, large-scale and voluntary disclosure exercise, as well as responding to your inquiry's specific requests for information. At the outset of the inquiry's evidential hearings in October 2020, the then Home Secretary provided a detailed opening statement which addressed the genesis of the inquiry, the role of the Home Secretary and the Home Office within it, and the constitutional and regulatory framework relating to the Home Office and policing in general, and undercover policing specifically, since 1968. And, of course, the relationship between the Home Office and the SDS. The regulatory framework relevant to undercover policing has developed considerably since the Tranche 1 period, as of course has been the case in respect of policing more generally. And the Home Secretary wishes, if you will allow me to do so, to reiterate the points made at paragraphs 25 to 27 of her predecessor's October 2020 opening statement. And so if you'll bear with me, I will just take a moment to repeat the contents of those paragraphs, as it is important in the Home Secretary's view that the public is aware of and has confidence in the current regulatory framework and understands that undercover policing is operated and managed very differently now to the way in which your Tranche 1 investigation has found it to have been operated and managed 40 or 50 years ago. Prior to the enactment of the Regulation of Investigatory Powers Act 2000, known in the trade as RIPA, in October 2000, the use of undercover agents was not governed by statute, but was underpinned by non-statutory guidance and codes of practice, and subject to rules established by case law and other statements of principle. These included Home Office Circular 97 of 1969, entitled Informants Who Take Part in Crime, and the ACPO Terms of Reference for a Special Branch, dated the 8th of April 1970. These were replaced in December 1984 with the Home Office Guidelines on the Work of a Special Branch, which were then updated in November 1994. And of course, those 1984 guidelines are dealt with in detail in counsel to the inquiry's opening statement for the purposes of modules 2B and 2C. Now, arrangements for undercover deployments are very different today from those prior to 2000. The introduction of the Human Rights Act, RIPA, and the Investigatory Powers Act of 2016 have fundamentally changed the legal context in which covert policing takes place. The present position is that all undercover deployments must be authorised as both necessary and proportionate to the issue being investigated. Since January 2014, all police deployments of undercover officers must be authorised by an Assistant Chief Constable and notified to the Investigatory Powers Commissioner, formerly the Office of Surveillance Commissioners. In addition, Chief Constables must authorise deployments which last longer than 12 months and seek prior approval for such deployments from the Investigatory Powers Commissioner. The level of authority for emergency, that is very short-term authorisations, has been raised from inspector to superintendent level or equivalent. More recently, the Covert Human Intelligence Sources Criminal Conduct Act of 2021 has introduced amendments to RIPA, providing a statutory regime for the authorization of criminal conduct by covert human intelligence sources, including undercover police officers, for specified purposes where necessary and proportionate and subject to robust safeguards. The Covert Human Intelligence Source Draft Revised Code of Practice was laid before Parliament in October last year, demonstrating that the regulatory framework continues to develop. So in summary, sir, the statutory framework and regulatory context is unrecognisable today from that which pertained during the Tranche 1 period. And the last 4 decades have seen enormous improvements in this regard. Now, we point this out not to diminish or mitigate any of the issues of concern identified during the 1968 to 1983 period. And we recognise, of course, that the current arrangements relating to undercover policing will be scrutinised by you at a later stage of this inquiry. But we do so because it is important, in the Home Secretary's view, that all those concerned with the business of this inquiry continue to understand that the conduct which led to the establishment of your investigation would not be permitted to take place today. So having made those general remarks in relation to undercover policing, can I turn to Tranche 1 and Modules 2B and 2C in particular? The Home Secretary has followed the evidence taken by the inquiry in relation to the conduct of SDS officers and managers between 1968 and 1982 with great care, and has noted a number of issues regarding the Home Office's role that have been flagged by the inquiry for further investigation. She will, of course, endeavour to her fullest capability to assist with those points as the inquiry progresses. Module 2C of Tranche 1 is the first of the inquiry's modules, in respect of which the inquiry has sought witness statements from former Home Office officials. Witness statements from 5 individuals were sought, and 4 of those individuals duly provided lengthy statements addressing detailed lists of questions posed to them by the inquiry. The 5th was unable to do so for reasons of ill health, as you know. In each case, the individual in question was asked for and provided evidence relating to their own personal involvement in and recollection of the matters of interest to the inquiry. They are all long retired and did not speak on behalf of the Home Office now, and nor, of course, were they asked to do so. Inevitably, given the period under investigation, all 4 individuals struggled to greater or lesser extents with their recollection of events that took place 40 or 50 years ago. But they did their best to be as helpful as possible, assisted in some respects by the contemporaneous documentation. As the inquiry is aware, all of the Home Office witnesses sought to provide the inquiry with the fullest possible answers to the questions they were asked, and it is apparent from the detailed summaries of the evidence helpfully produced by counsel to the inquiry that they have been able to shed at least some valuable light on the relevant events. So we note and we take no issue with your decision to conduct this part of the inquiry as a paper-based exercise without witnesses being called to give oral evidence. But of course, if there is further evidence or any other further assistance you require in order to conclude this phase of your investigation, the Home Office is very anxious to provide it to you. The detailed and forensic analysis of counsel to the inquiry, as set out in their opening statement and supplemented in their closing submissions, has been considered with care by the Home Office. We do not propose to comment on it here. It will be for you to reach your own conclusions on the basis of the contemporaneous material and, to the extent that they assist in interpreting that material, the recollections of the available witnesses. We would observe simply that the conclusions of counsel to the inquiry as to the lack of knowledge on behalf of the Home Office of the inappropriate activities of certain SDS officers, as summarised at paragraphs 87 and 88 of the opening statement, accord with our analysis of the evidence, and we would respectfully endorse them. We would also observe, having reviewed the closing submissions of the other court participants, that none of them have identified any evidence of any awareness on the part of the Home Office, either as an institution or on the part of individual officials, of inappropriate conduct of the type with which this inquiry is primarily concerned, including sexual relationships with activists, the use of identities of deceased children, or criminal activity on the part of SDS officers. On a number of occasions, general terminology to the effect that the Home Office was aware of, for example, quotes, the manner of work done by SDS officers, has been used in some of the court participants' submissions. We would respectfully observe that considerable care has to be taken with general assertions of that nature. Awareness of the existence of the SDS and its engagement in covert undercover policing is one thing. Awareness of misconduct on the part of individual officers and managers in the discharge of those functions is quite another. And, as has been correctly identified, we submit by counsel to the inquiry, there is no evidence of the latter on the part of the Home Office. So can I simply say this by way of conclusion? The Home Secretary reiterates her cooperation with the inquiry and welcomes the efforts by you and your team to conclude the inquiry within a reasonable time. She acknowledges the breadth and depth of evidence heard and the work undertaken so far, and awaits with keen interest the findings of the inquiry in Tranche 1 in your interim report. So that concludes the submissions that the Home Secretary wishes to make at this stage of the inquiry. Thank you very much.
Thank you very much, Mr. Sheldon. May I reiterate what you said about the Home Office witnesses and express over the live link my gratitude to them for taking the time and trouble which they did to produce the helpful statements which they did produce.
We're very grateful for that, sir, and I'll make sure it's passed on to all of them.
Thank you.
Thank you.
Ms. Murphy.
Good morning, sir. This closing statement is made on behalf of the Category F core participants, the families. The families are the bereaved relatives of loved ones who died in childhood and whose legal identities were appropriated by the Metropolitan Police. They are Frank Bennett and Honor Robson, Faith Mason, the Lewis family, Lisa and Mark Crosland, Emma Richardson, the daughter of Barbara Shaw, and a family who have asked to be designated the restricted family, to use that designation. They are the bereaved relatives of a child who died. And this family have been constrained to participate in this inquiry anonymously by reason of a restriction order covering their own identities and that of their dead relative. An order made necessary by the Metropolitan Police's use of the identity of their dead relative. Common to the families are the precious memories they guard of the children they have lost. The children's legal identities were a fundamental aspect of their short existences and will forever retain importance in each family's memory of them. The Metropolitan Police's use of the identities of the family's children spanned a period of over 20 years, but the impact of the Metropolitan Police's actions extend far beyond, as the family's precious memories have become forever inextricably bound to the activities of the SDS and the officers it deployed. Memories that for the families have been tainted forever. The officers' lawyers point out that none of the relatives notified regarding use of their loved ones' identities in the Tranche 1 period wished to participate in your inquiry. And they point out that only a quarter of those whom you have notified that they were affected by the practice have indicated, to use the officer's lawyer's word, disapproval. They continue that they, quote, would not wish to deny the hurt and distress experienced to some families. And that particular theme is picked up by the Commissioner of the Metropolitan Police himself, who seeks to acknowledge the shock and distress experienced by, again, some of the families of the children whose identities were used. So the family make 3 points regarding this. First, that those statements should bring home to you, sir, the importance of this inquiry and of your conclusions. Those are not statements made by an organization or by individuals who have grappled with the impact of their actions. Without acknowledging impact, lessons will not be learned. Without an understanding of the reasons why learning is necessary, change will not come. In Tranche 1, you have considered the first 15 years of one small unit within the Metropolitan Police, a unit that was not ignorant of law, morality, and ethics. It deliberately disregarded those tenets. And you have heard evidence of how its leaders facilitated, in fact, caused a toxic culture to fester and to permeate SDS operations. And it is long past time for the Commissioner and his officers to cease defense, to cease minimization of the impact of their actions. And it is beyond time for them to pivot towards change, permanent, forever change. And you, sir, will be mindful that in communicating your opprobrium for what you have heard of the behavior of officers, senior officers at the time, and in several instances, much more senior in the years that followed, you will, the family's hope, contribute to meaningful, permanent, forever change. Change to an organization that has demonstrably failed to seize that opportunity for itself. Secondly, the families we represent contribute to this inquiry in the hope of contributing to this necessary change. They do so at significant personal cost, as you have seen. Nothing is to be judged or inferred from the fact that others have not proven able or willing to make an equivalent sacrifice. Thirdly, the impact upon the family has gone far beyond disapproval, and it has gone beyond shock and distress. The officers, lawyers, and the Commissioner are or should be fully aware of the family's sense of betrayal, of anguish, of the forever impact on their lives. And those are experiences that overlay their traumatic bereavements. And in the case of the restricted family, treatment that has been humiliating, degrading, and debasing in violation of the rights protected by Article 3. And you, sir, have considered a bundle of factual and expert evidence in that regard. The families consider that the wrong that has been done to them arose from heinous institutional failings on the part of the Metropolitan Police, and that the responsibility lies with senior Metropolitan Police officers who directed and or condoned the wrong that was done to them. So if I might make some short remarks in relation to the legal context. Our submission in brief is that, of course, your judgmental conclusions should be by reference to the legal framework applicable to the Metropolitan Police. The framework applicable in 1829, when the Metropolitan Police was formed, in 1833, a date to which we will return, the Tranche 1 period, and today. A public inquiry is about public accountability. And in the policing context, that inevitably means accountability to the rule of law. Our more detailed submissions as to the legal framework are set out in our written submissions, but we emphasize 4 points. First, the British unwritten constitution has long required the police to subjugate their activities to the rule of law, to engage in only those activities that would secure and maintain public respect. So that, in the words of Lord Denning from 1968, honest citizens may go about their affairs in peace. Secondly, we return to 1833, and we are grateful to the designated lawyers group for alerting us to a select committee report of the House of Commons into an investigation convened in 1833 to consider the infiltration by a police inspector into the activities of the Camberwell and Walworth branches of the National Political Union of the Working Classes. An investigation resolved rather more quickly than a modern public inquiry. Members of the union had raised strenuous objection to being compelled to, quote, pay for the maintenance of spies under pretense of there being persons employed for the preservation of the peace. The committee concluded that the inspector had in fact taken an active personal role in the proceedings of the union, when, to quote from the committee, his duty only required him to observe. And the committee criticised the inspector for having, quote, carried concealment and deceit into the intercourse of private life. The officers' lawyers rely upon what they describe as the committee's approval of the use of undercover policing, including the methods of the SDS. But what the committee in fact emphasised was that the occasional employment of police officers in plain clothes to detect breaches of the law and to prevent breaches of the peace might be acceptable if those objectives were otherwise unattainable. But they also said this, that they strongly urged the most cautious maintenance of those limits and solemnly deprecated any approach to the employment of spies in the ordinary acceptance of the term, as a practice most abhorrent to the feelings of the people and most alien to the spirit of the Constitution. So it was in 1833, so it was in 1968, 1982, and so it is today, sir. Material to this point is the request by the officers' lawyers and the current Commissioner of the Metropolitan Police to ask you to investigate whether the security services relied upon the identities of dead children. And I note that that complaint has continued into their closing submissions. Whether they raise that topic by way of justification or mitigation, it's not entirely clear. But either way, their reliance is entirely misplaced. The police should not have been behaving as spies, and they should not for 1 second, justify their behavior by reference to the conduct of spies. The fact that their efforts at justification extend to the operational activities of the KGB rather serves to underline that particular point. Sir, Article 8. We say that Article 8 is of particular assistance to the inquiry in its consideration of this topic, because it provides clarification as to the nature and scope of the police duty not to interfere with the private lives of citizens. This being an area in which European and domestic jurisprudence has marched in step, and in providing a framework for the inquiry's consideration as to whether the interference with the private lives of the families is capable of justification. We, of course, say it is not and has not been. But leaving to one side our bemusement that the police core participants seek to discourage you from addressing legality in the formation of your judgmental conclusions, the use of real identities by the undercover police officers obviously engaged the criminal law, and we've set out in our paper the several criminal law provisions that are pertinent. And we make this point: the police are criminal law specialists. They are familiar with offences, and they ought reasonably to have done everything in their power to stay on the right side of the line. But it is telling that in contrast, Geoffrey Craft told you, sir, that he actually gained confidence in this operational methodology from his knowledge of a KGB agent's reliance upon it. An investigation in which he was involved, Mr. Mulvena, and which resulted in that KGB agent's conviction of a criminal offence associated with the method by which he had constructed his identity, the same method as was then used by the SDS. So we find ourselves returning to the distinction between police and spies. We say that that was a distinction willfully ignored by the senior officers responsible for the SDS. Some observations with regard to the evidence, and we begin by addressing the "we had no other choice" defense advanced by the Commissioner and by the officers. The methodology described by Conrad Dixon concerning the assumption of cover identities and approved by Mr. Ferguson Smith and represented to the chain of command in 1968 as reflecting the actual and intended operational practices of the SDS, in fact, bore no resemblance to the reality, and there was no action taken by them or any other to implement professional working practices. The early officers describe a casual and ad hoc approach, a lack of supervisory involvement or even interest, an absence of any training, guidance or instruction, and being, in effect, left to their own devices. And the officers who were deployed after Mr. Dixon had deposed the purported working practices of the SDS to his document penetration of extremist groups, similarly operated without any adequate supervisory involvement, training, guidance, or instruction. There is no evidence that any managerial concern was brought to bear upon the risks associated with relying upon fictitious identities. On the contrary, Conrad Dixon and Mr. Ferguson Smith represented that fictitious cover identities subject to certain safeguards were capable of withstanding scrutiny. There was no genuine concern about the efficacy of relying upon fictitious identities and no assessment of the necessity of conversion to the post-1974 practice. There is some evidence that officers deployed in the early phase of the SDS operations, perhaps relying on prior special branch experience, appreciated that staying within the confines of their intended role better protected their cover, and appreciated the importance of not readily giving up information from which a check of public records could be made. HN 34 said that he did not want to become too close to anyone, as it would have made a compromise more likely. And HN 348 said that she was there as an observer, not as a participant. And that has resonances with the Committee of Parliament back from 1833. And it was not, she explained, difficult to avoid really revealing information because the people she was observing were very vocal, keen to have an audience, and didn't ask her questions about herself. But those officers were the exception because most officers didn't have a strategy to maintain their cover. They were left to their own devices and they played it by ear. They became closely involved in the private lives of those whom they were observing, and worse. This is, of course, material because once suspicions were raised, there was always the possibility that public records might be checked, and all options carried significant risk once that stage had been reached. The approach to the creation and reliance upon cover identities was no more professional after the adoption of the post-1974 practice. And given the continuing lack of training, guidance, instructions, and managerial input, the approach was unsurprisingly inconsistent. Further, the SDS operational conduct in this period was similarly at odds with the practices that were being represented by senior SDS officers to their chain of command, as reflected in the annual reports. The 1976 annual report asserted that officers were provided with, quote, the strongest possible cover backgrounds compatible with the modern computer age. And it's a matter of obvious concern to the families that Sir Mark Rowley is buying into that same fiction, the same fiction that Conrad Dixon represented to his superiors, and the same fiction that was represented up the chain of command by Conrad Dixon's successors. In his closing argument, this phase of your inquiry, the Commissioner states, quote, it was essential for undercover officers to create credible identities that could withstand proactive close scrutiny. But the history of the repeated compromise of officers, often through their own stupidity and even criminality, makes plain that these officers were not taking care to create credible identities. That was not seen as essential. The senior officers did not train, guide, or manage them to take care. Credible identities were not a priority for the SDS. The officers were left to run amok. To the extent that any potential operational justification for the post-1974 practice emerges from the Tranche 1 evidence, it appears to be based on the suggestion that a rail birth certificate was the root document from which identity documents might be obtained, and that the subjects of SDS operations might more readily establish that the assumed identity was of a living person than they might establish that the assumed identity was of someone who had died. And the family's position is that that simply does not stand up to scrutiny. First, the pre-1974 officers were provisioned with a range of identity documents, notwithstanding their reliance upon fictitious identities. Secondly, professional conduct in the field, to which scant attention was paid, afforded the best protection against falling under suspicion, and without suspicion, a check would not be made. Thirdly, once suspicions were raised, the likelihood of reliance upon the identity of someone who had died was an obvious follow-on suspicion, given the popularity of this method and its repeated references in popular culture. Death records could be readily correlated with birth certificates, relying upon the locality indicators. And finally, on this point, organizations of civil society and individuals who suspect they are being deceived as to the identity of someone in their midst, as the actions of the individuals affected and participating in this inquiry attest, they will be determined in their pursuit of the truth. The mere finding of a birth certificate would not quieten such suspicions. There was cause for the SDS to reflect upon this reality in the very early phase of its reliance upon the identity of dead children, but the practice was nevertheless persisted in. There were egregious failures on the part of senior SDS officers in failing to take any adequate steps to ensure that deployed officers maintained basic standards of professionalism in their deployed roles, and in failing to have any adequate regard to the operational limitations and risks of relying upon the identities of dead children. I intend to touch briefly on the topic of responsibility, because no one admits responsibility. In October 2020, it was said on behalf of Cressida Dick, Mr. Riley's predecessor, that evidence will be given as to why the practice of relying upon dead children's identities was considered necessary at the time to support the work of undercover police officers. But in fact, USER have not been provided with any evidence as to why the post-1974 practice was considered necessary at the time. Similarly, the designated lawyers group, in their opening statement to Tranche 1, observed that the reliance on fictitious cover identities was, quote, reviewed and abandoned after a number of undercover officers were compromised or outed. Again, there has not been a scintilla of evidence adduced in Tranche 1 to support that assertion. You will have reached your own view as to the credibility of the evidence you heard from Derek Bryce. The family make the following points. The post-1974 practice became the embedded operational practice of the SDS during his tenure. There is an irreconcilable conflict between his evidence and that of Mr. Smith as to his state of knowledge. He described his role as that of quartermaster, with responsibility for supplying things they needed and making sure they were safe. In the SDS context, provisioning necessarily entailed cover document provision and the creation of cover identities. And the post-deployment utilization of those identities were the essential elements of keeping an officer safe. And the SDS was a very small unit, with Derek Bryce, one of only 3 senior officers working in the back office, and it is improbable that he would not have been aware that officers were spending significant time at St. Catherine's House, seeking out the identities of dead children, and that a member of the back office team was accompanying them there from time to time. And finally, on Mr. Bryce, his attempt to time the introduction of the post-1974 practice to a period after his tenure, prompted, as he said, perhaps by the day of the jackal, was singularly unsuccessful. The practice began to be embedded from the spring of 1974. The film was released in 1973. So the family invite you to reject his evidence and to conclude that he was in fact fully aware of the post-1974 practice. Whether his unwillingness to admit knowledge had arisen deliberately or through the operation of wishful thinking, the family submit that the more important point is that his reluctance to accept knowledge is only consistent with the stark fact that the post-1970 practice was obviously repugnant, whether viewed from the perspective 1974 or today. And it ought, at the very least, to have been the subject of extremely careful consideration before being rejected out of hand. My next topic is to consider the ethics defenses that have been advanced by the Commissioner and the individual officers. So firstly, Sir Mark Rowley, his position is no one thought to consider it at the time. And the designated lawyers group make reference to World War II and tell you that child and infant mortality rates were higher in the 1970s than they are at this time. So when we scrutinize the actual evidence, it's not true that no one considered the ethics at the time. The individuals who considered the ethics at the time were the frontline officers. HN 336, deployed in early 1989, said he could not imagine the anguish it would cause to the family of a deceased child to learn that the child's identity had been used in such a way. HN 200, recruited to the SDS in April 74, told you, quote, "I did query whether it was necessary to do this. It wasn't something that sat comfortably with me, and that it had caused him upset, bearing in mind the possibility of the family finding out that he was relying upon the identity of their dead loved one." He went on to challenge his superior, stating, "Why is that necessary?" We say that you had some very telling evidence from the wife of HN 13. He was deployed in early 1975. And she had a strong recollection of being told by her husband that his cover name was the surname of a deceased child. And she stated, "It only had to be said once for it to be imprinted in my mind." Indeed. And Vincent Harvey, joining the SDS in 1976, told you that he appreciated the risk. He said, unless extreme care was taken, there was a risk of a parent being approached or a death certificate being found. And he stated the risk of being confronted with the child's death certificate was obviously in the back of your mind. There is constantly the concern that you might be identified as a police officer, whether by the death certificate or another reason. HN 80, deployed into the field between about March 1977 and March 1982, stated that the practice of reliance upon dead children's identities distressed him so much that he initially refused to rely on it. He said, "It distressed me to consider using the details from a dead child's birth certificate, and I knew that it would necessarily cause distress to that child's family if it was discovered." He had a long discussion with Mr. Ferguson and insisted upon combining elements of a deceased child's identity with fictitious details and truthful details, such as his own date of birth. The risk of a family finding out was always present. It was a risk brought to the forefront of senior officers' minds as a result of the Big Flame members presenting Richard Clarke with the death certificate of the child whose identity he had taken. But they carried on despite the obvious legal, moral, and ethical objections, because that was very much the modus operandi of the SDS generally. And as to the designated lawyer's position that World War II had hardened the perspective of the senior officers, an explanation you will recall, sir, that was advanced by David Bicknell, we also invite you to reject that argument and the companion argument now advanced by the designated lawyers group that infant and child mortality rates were higher in those days. So the experience of war is as likely to underline the importance of human life and the special gravity of being bereaved of a child. You have the evidence from the frontline officers and you have the evidence from HN13's wife. And we invite you to conclude that the senior officers were willfully, recklessly ignoring the obvious moral implications. Briefly on the topic of origins, sir, you have endeavoured to examine the origins of the practice, including knowledge and responsibility for the change. Because of course, that is of assistance in examining the validity of the Metropolitan Police's claim to operational justification. And the family's analysis is that the most likely precipitant was nothing more than the 1973 film adaptation of the Frederick Forsyth book. On our analysis, more fully developed in our written submissions, this was the precipitant. Adoption of the practice was not driven by operational considerations. The Day of the Jackal was published in 1971 and the film adaptation released in cinemas in May 73. So the release of the film fell in close temporal proximity with the SDS move from reliance upon fictitious identities to those of dead children. And HN 126, who served in the SDS shortly after the introduction of the practice, told you that they had all watched The Day of the Jackal a couple of years earlier when it came out. And it was his understanding that using the identities of dead children was an idea that had sprung from there. And he explained that the jackal, or the Day of the Jackal, was used as a nickname by him, and he was sure that he was not the only one to use that term in connection with the technique. And we say his evidence has a ring of truth about it. The film was a critical and commercial hit, likely to have appealed to the law enforcement community, and most particularly those involved in undercover work. Perhaps the film's release brought to Mr. Roger or Mr. Kraft's mind the details of the methodology relied upon by Mr. Mulvena. And unfortunately, although Geoffrey Kraft provided you a statement on the 7th of December 2020, in which he stated in unequivocal terms that, quote, the idea of using a deceased child's identity came from Forsyth's Day of the Jackal, by the time he gave evidence 18 months later, he sought to, in his word, correct that account, stating in evidence that the method had merely been popularized by this work, and he did not know how the practice had started. And he therefore, or thereby, aligned his account with the evidence that David Smith had given 2 days previously and Derek Bryce the day before. And he distanced himself from the institution of the post-1974 practice. Irrespective, what is important is that the methodology was a well-known device, well-known among police officers, well-known among the intelligence community, and well-known by the public at large. So in relation to conclusions, we invite you, sir, to conclude that the failure to bring any meaningful managerial oversight to bear upon the practices of the deployed officers in the period before and after the SDS started to rely upon the identities of dead children is highly material to the conclusion we invite you to draw, that the Metropolitan Police has failed to establish operational necessity for the practice. And the families also submit that the history of compromise in the Tranche 1 period is of assistance in dispelling the operational justifications advanced by the Commissioner and the designated lawyers group. The very real operational risks highlighted by the events surrounding Richard Clarke militated against the post-1974 practice. The failure to reflect on those events and the other compromises and potential compromise events, in combination with the failure to establish basic standards of professional working practice, are only consistent with reckless reliance upon the practice. And in considering the family's submission that you should conclude that senior officers willfully disregard the legal, moral, and ethical implications, the families invite your particular attention to the absence of any consideration by those officers of the relative operational effectiveness of the alternative methods and the obvious nature of the harm that would be occasioned to affected families. A risk that was obviously identified because frontline officers took some steps to avoid it. The SDS operated at the edges of legality and morality, and what became its embedded operational practice, including the practice in relation to the identities of dead children, were operational practices that went far beyond those norms. The Tranche 1 evidence has established that senior officers were content to condone and indeed encourage such working practices. The focus of their concern was to ensure conditions of maximum secrecy, appreciating, whether consciously or not, that if the abhorrent working practices of the SDS were to be exposed, the resultant public outcry would bring embarrassment upon the Metropolitan Police, ignominy upon themselves, and an end to the SDS's activities. And we invite you to conclude that whether judged by the standards of the 19th century, the 20th century, or this, it was entirely obvious that the creation of a lawless clique of undercover police officers deployed under cover of the identity of dead children was as unlawful and unconstitutional as it was unethical and immoral. Thank you, sir.
Thank you very much indeed. As you rightly observed towards the beginning of your submissions, I cannot and will not deal with the impact of the use of deceased children's identities until those who are willing to speak of it have had the opportunity of doing so.
Thank you, sir. That is understood. I'm grateful. Thank you.
Thank you. Mr. Jacobs.
Good afternoon, sir. I make this statement on behalf of Celia Stubbs, instructed by Simon Crichton of Bat Murphy Solicitors, both of whom are present with me in the room as I make this statement. So I'm going to largely canvass the ground covered in my written submissions, save for some additional matters by way of response to submissions made by others, particularly those of the designated lawyer. So at the outset, could I ask for Doc 020 to be brought up on screen? Doc 020. Thank you. Sir, Celia Stubbs was the partner of Blair Peach, who is pictured in that photograph. Blair Peach was killed by a police officer striking a blow to Blair Peach's head during a protest against racism in Southall in April 1979. The circumstances of his tragic death and the sustained cover-up that followed it are told in Celia Stubbs's statement and were set out in the opening by us to part 2 of this tranche of the inquiry. It is a story, ultimately, of police officers and the Metropolitan Police colluding and conspiring to conceal the true circumstances of Blair Peach's death and to evade accountability. So that photograph can be taken down. Thank you. At the conclusion of this tranche of the inquiry, the central conclusions invited by Celia Stubbs are as follows. First, that the SDS, on behalf of Special Branch and the Metropolitan Police, targeted and covertly gathered intelligence on Celia Stubbs and the campaign for justice concerning Blair Peach over a period of decades. Second, the purpose of gathering such intelligence had nothing to do with public disorder. It was concerned solely with protecting the Metropolitan Police from criticism and its officers from justice. The intelligence was, we say, as a matter of fact, used for that purpose. Third, the deployment of undercover officers and gathering of intelligence with that purpose was wholly unjustified. Fourth, the targeting of any peaceful justice campaign by undercover officers would be wholly unjustified, but it was particularly duplicitous and abhorrent in circumstances that the Metropolitan Police knew full well that Celia Stubbs and the Blair Peach campaign was seeking to uncover a grave injustice and the true circumstances in which Blair Peach had been killed by an officer of the Special Patrol Group. So the truth about the killing of Blair Peach and the fact that the Metropolitan Police had known the truth all along only became public knowledge following the publication in April 2010 of the report of Commander Cass, which had been written some 30 years earlier. The reports were released with the Metropolitan Police stating that 14 witnesses said they saw a police officer hit Blair Peach, and there is no evidence which shows he received the injury in any other way. This, of course, is and always has been a grave concern to the Met. We acknowledge the stress, suffering and upset his family and friends must have felt at the time of his death and subsequently. That is what was said in 2010. But, sir, it certainly was not a, quote, grave concern, unquote, to the Metropolitan Police in the 1980s when the reports and the truth were concealed. At that stage, the Metropolitan Police was perfectly content for the inquest into Blair Peach's death to be misled and the responsible officers to evade justice. The publication of the report in 2010 offered some small measure of truth, but it was far too late to achieve any measure of accountability. In the decades between Blair Peach being killed and the publication of the Cass reports, Celia Stubbs had campaigned for truth and justice. With friends of teachers who worked with Blair Peach, she established the Friends of Blair Peach Committee, or the FBPC. Her campaigning was valiant and it was dignified. It was entirely peaceful, always, and pursued the means of peaceful campaigning and recourse to the rule of law. She also supported other people who were campaigning for justice and seeking police accountability. She was a founding member of the charity Inquest, which still exists today and every year supports hundreds of bereaved families in seeking justice for their loved ones who have lost their lives in police and prison custody and other settings. She was also a member of the Hackney Community Defence Association and the Colin Roach Centre. As she said to you, sir, in her statement, all of these campaigns have been about strengthening civil society, campaigning on issues like legal aid, lawyers' groups, and parliamentary lobbying. Celia Stubbs now knows that notwithstanding her peaceful and lawful pursuit of truth and justice, she was the subject of repeated intelligence gathering by Special Branch, including by the undercover officers of the SDS. The fact that the state was deploying resources to gather intelligence on her and treating her as if she was a criminal or a threat to law and order is, to Celia Stubbs, extremely distressing. So too, sir, is the content of much of the reporting, which is demeaning and dismissive. Celia Stubbs was seen by Special Branch as nothing more than, quote, a mere propaganda tool, unquote, for the left. That she may have been a victim pursuing a just cause of accountability for a Metropolitan Police officer killing her partner did not register with Special Branch. The questions which loom large for Celia Stubbs, and which the terms of reference for this inquiry demand an answer, are: why were undercover officers deployed to gather intelligence on Celia Stubbs and the Blair Peach campaign, and to what end? The picture which has emerged is that the Metropolitan Police in the 1980s, and it appears in the years since, has maintained an intense and determined interest in police accountability groups and campaigns for justice in respect of wrongdoing by police officers. It pursued that interest through Special Branch. That interest had nothing to do with fear of public disorder or fighting crime. It had everything to do with the Metropolitan Police and Special Branch perceiving accountability and justice as a nuisance and a threat. Intelligence was gathered by Special Branch on police accountability groups and justice campaigns to help the Metropolitan Police respond to that perceived threat. The SDS and its undercover officers targeted Celia Stubbs in the campaign in order to serve that intense interest of Special Branch in police accountability groups and justice campaigns. The deployment of and targeting by undercover officers was not the subject of any formal or rigorous process of careful selection and justification. Instead, it appears, as is the impression, undercover officers were Special Branch men who knew what Special Branch were interested in, and Special Branch were interested in justice campaigns. We say, sir, that targeting a campaign for justice, such as the Blair Peach campaign, could never be lawfully justified unless there was some reason to consider that the campaign was conspiring to perpetrate significant crime. To target the campaign to serve the interests of Metropolitan Police in police accountability groups in general, and to frustrate access to the truth in this specific instance, was unjustified. So that's a summary of our position, but we proceed as follows, and by addressing the following questions. How were Celia Stubbs and the Blair Peach campaign targeted by the SDS? What was the motivation for targeting Celia Stubbs and the Blair Peach campaign? What was the effect of the undercover policing targeted at Celia Stubbs and the Blair Peach campaign? And was the undercover policing justified and lawful? So, sir, turning to that first question, how was Celia Stubbs and the Blair Peach campaign targeted by the SDS? A timeline of the SDS reporting on Celia Stubbs and the Blair Peach campaign is set out in a table annexed to our written submissions. The timeline highlights what is now known of the activities of the SDS and Special Branch in respect of Celia Stubbs, and when and how evidence was disclosed to her by the MPS, either by this inquiry, sir, or on her own motion via a subject access request. The timeline demonstrates that as a non-state core participant, Celia Stubbs has made an important contribution to the effectiveness of the inquiry. We see, sir, from that timeline that the gathering of intelligence on Celia Stubbs by the SDS and more generally by Special Branch commenced in the 1970s, intensified after Blair Peach's death in April 1979, and continued at least into the 1990s. It followed not only her campaign in respect of the killing of Blair Peach, but also her involvement in other justice campaigns. Both Celia Stubbs and Blair Peach were the subject of Special Branch registry files prior to Blair Peach's death in 1979. She also appeared in a limited number of SDS reports, with her reported as being present at the inaugural public meeting of the Hackney Community Relations Council in August 1976, and a meeting of the International Socialists in July 1976. Two Special Branch reports of 1978 noted details of Blair Peach's car and his relationship with Celia Stubbs, and also an incident of Celia Stubbs wearing an anti-Nazi League lapel badge, being assaulted by two members of the National Front and suffering bruises and lacerations to her face. However, following Blair Peach's death, the subsequent campaign for justice was immediately the subject of intense scrutiny and SDS reporting. The campaign features in various SDS reports, such as reports of a Socialist Workers' Party meeting in April 1979 urging attendance at a peaceful vigil, at a meeting of 3rd of May 1979 referencing the Socialist Workers' Party conducting its own investigation. And on the 23rd of May 1979, the SDS provided a list of persons present at a demonstration regarding Blair Peach's death organised by the Indian Workers' Association. On the 30th of May 1979, an SDS report attached a leaflet produced by the Friends of Blair Peach Committee. The leaflet described that answers were sought to the questions: who killed Blair Peach and why? What were the activities of the police, especially the Special Patrol Group in Southall on April the 23rd, and what orders were given and by whom? The leaflet suggested actions such as phoning a local radio station, writing to the local newspaper, contacting a local MP, and organising pickets. So you can see it was not remotely subversive or remotely concerned with inciting disorder. A report of 4th of June 1979 noted a connection between the Blair Peach Committee and the SWP. Several reports referenced plans for pickets at police stations and at the inquest, and some of those reports listed those that were in attendance. A source of significant distress for Celia Stubbs is that undercover officers of the SDS were present at Blair Peach's funeral on 13th of June 1979. A report listed a number of individuals present at the funeral, and other reports included photographs of some of those in attendance. According to the gist of the closed statements, one officer describes attending the funeral. An SDS report of July 1980 reported that the Friends of Blair Peach Committee were at present attempting to form a national coordinating body with other such committees concerned with cases of state brutality by the police and prison authorities. Special Branch officers preparing intelligence reports were clearly aware of and disseminating information relating to the strategies pursued by Celia Stubbs and the campaign. A Special Branch report of February 1982 described her as attempting to provoke the police into commencing libel proceedings, thus seeking to reveal internal plans of the campaign. It is also apparent that SDS interest in the campaign regarding the circumstances in which Blair Peach was killed, or at least the campaign, did not diminish even over the many years that followed. A report of April 1989 on a meeting of the Blair Peach 10th Anniversary Committee is stated to be from a secret and reliable source, which indicates an undercover officer. That is a report obtained by Celia Stubbs via a subject access request. Similarly, a report of July 1998 with the heading, quote, touchy subject, unquote, reported that April of that year represented the 20th anniversary of the death of Blair Peach, and to commemorate the event, local trade unions were organising a large rally and demonstration, which it said would be presented with a strong anti-racist, anti-police flavour. The report, which we understand to have been prepared by undercover officer Mark Jenner, also suggests that the event would attract anti-police type groups and that the potential for disorder would be significant, albeit disorder, sir, would have represented a departure from the preceding 20 years of peaceful campaigning. There was, of course, no disorder. So that, sir, is a potted summary of the intelligence gathering by the SDS and Special Branch on Celia Stubbs and the campaign. And we turn, sir, to consider what was the motivation for targeting Celia Stubbs and that campaign. So at the conclusion of the evidence of this part of the inquiry, it is evident that the targeting of Celia Stubbs was motivated by a desire to serve Special Branch's general interest in police accountability groups and campaigns for justice. That interest was driven in part by Special Branch viewing police accountability as anti-police and anything anti-police or indeed anti-racist or feminist or pro-gay rights as extremist and subversive. It was driven by a desire to protect the police from accountability and to defend the police in relation to legal proceedings arising from their actions. That's revealed, so we say, from consideration of the following: the interest of Special Branch in police accountability groups generally, and the evidence as to that, the interest of Special Branch in the Blair Peach campaign in particular, the evidence as to the use to which evidence gathered was put, how SDS targeting sought to serve the general interests of Special Branch, and that reporting on the campaign could not have been simply incidental to other objectives. So turning to the interest generally of Special Branch in police accountability groups, we note 2 points at the outset. First, some of the Special Branch documents before you use the term police accountability groups to refer to both those groups concerned with the general concept and mechanisms of accountability and those individuals or groups working with individuals seeking accountability and legal redress for specific incidents, what we would describe as a justice campaign. These individuals and groups were either pursuing or were subject to formal legal processes and are more accurately described as justice campaigns. Second, sir, to recognise at the outset that the disclosure sought by the inquiry from Special Branch, as opposed to the SDS in particular, has been limited. The inquiry has not sought full disclosure of the interests of Special Branch in police accountability groups and justice campaigns. Irrespective of the merits or otherwise of that approach, it is inevitably the case, sir, that what has been revealed so far in this inquiry can be no more than glimpses behind the veil of the interests of Special Branch which the SDS sought to serve. Nevertheless, those glimpses are sufficient, we say, to provide a clear picture of Special Branch having an avid and self-serving interest in police accountability groups. An important insight is provided by the extensive 44-page Special Branch report of January 1983, describing the actions of the then Labour-controlled Greater London Council, the GLC. The report describes in detail the democratic activities of the GLC in respect of seeking police reform and supporting groups seeking police accountability. The report reveals not only the intense interest held by special branch and police accountability groups, but also that the interest was highly political and largely driven by the wholly misconceived idea that police accountability was somehow subversive and posed an existential threat to the police. At that time, sir, each police area nationally was governed by a local police authority comprising local councillors and magistrates, save for the Metropolitan Police, that was governed by the Secretary of State, serving as the local police authority. The GLC believed that the Metropolitan Police should also have accountability to local communities in the same way as the rest of the country, even at that time. It campaigned to that effect and sought to take steps to have a role in the oversight and direction of the Metropolitan Police, including by supporting local police accountability groups and establishing borough police committees in each London borough. It was intended that by the GLC that these committees undertake steps such as monitor the policies and practices of the local police, develop crime prevention strategies, monitor the police complaints procedure, and exchange information and views on local police activity with local independent monitoring groups. Irrespective of the merits of the GLC's view, it was pursued with democratic legitimacy and was neither subversive nor extremist. Indeed, today, the Metropolitan Police Services falls under the supervision of the Mayor's Office for Police and Crime, which serves the same role in effect as a police and crime commissioner, and which replaced the previous area police authorities. That is the position in effect that was advocated in the 1980s by the GLC. Notwithstanding that democratic legitimacy, Special Branch took a keen interest, as is stated in the report, in terms, quote, Special Branch has attempted to follow the campaign in detail, and in so doing has collected a massive information about the personalities and groups involved, unquote. And the report was said to be an attempt to analyse and interpret that information. Undoubtedly, the message of the report is that there was something malevolent in the steps taken by the GLC intended to seek police accountability and in the groups it supported. However, identification of the supposed malevolence, which warranted the gathering of this massive information as described, is difficult, we say, to decipher. The report is scathing as to the use of public funds by the GLC, which it described as an irresponsible and profligate use of public money. But the use of public funds by the GLC could hardly be a proper matter for Special Branch. The report is entirely dismissive of the GLC's intentions, describing that its, quote, innocuous meetings with their solemn self-imposed responsibilities and grandiose self-perpetuating designs were merely the external trappings of the police committee's work, unquote. The report does describe that there were various extremist influences operating within the GLC and its two police bodies. But these extremist influences, so-called, were simply references to various left-wing campaign groups. Kate Allen was described as a militant feminist, and the then leader of the GLC, Jonathan Walker, was considered extremist as he was affiliated to the CND. Celia Stubbs herself is mentioned in the report in her capacity as part of the management committee of Inquest, which featured in the report given its interest in police accountability. As we have already noted, sir, Celia Stubbs and Inquest were concerned primarily with the rights of individuals seeking to call the police to account for their actions in relation to specific incidents, which were the subject of ongoing legal processes. Nevertheless, as characterised by Special Branch, Inquest was formed, quote, in May 1981 at the height of an orchestrated campaign which sought to infer that all deaths in police or prison custody should be seen as evidence of malpractice, unquote. Celia Stubbs and her colleagues were evidently to be viewed by Special Branch with suspicion as having been, quote, closely associated with the SWP and currently seen as Trotskyist sympathisers at least, unquote. The conclusion drawn by the report was that the campaign for police accountability in London was significantly influenced by political extremists whose motives were said to be questionable. As to the perceived threat posed by these groups, it was said that in the short term, they are clearly intent upon causing mischief for the Metropolitan Police Force, and it was said that in the long term, they patently aspire to control it. Thus, Special Branch feared both mischief and some sort of existential threat. The report's concluding remark is that whatever their motives, their efforts have nothing to do with the rule of law or the true interests of the people of London whom they claim to serve. Sir, the misplaced and intense interest and distrust and fear of police accountability groups is evident. It clearly, sir, strayed far beyond any proper policing role and into an evaluative assessment of legitimate democratic processes and the rule of law. And it was largely founded on Special Branch's own prejudiced view of the political left, its dislike of campaigns around racism and gay rights, and a distaste for accountability. So a number of observations can be made about this document. One is that subversive, whatever the niceties of its definition, had in practical terms become synonymous with anything that Special Branch felt to be of nuisance and anything relating to the political left wing and anti-racist and pro-gay rights campaigns. Another is that the determined briefing against a democratically elected body such as the GLC was an affront to local democracy. However, the key point for your purposes, sir, is that it reveals the purpose of Special Branch targeting police accountability groups and justice campaigns as one of protecting the force from scrutiny or criticism. Significantly, the inquiry has disclosed an accompanying minute sheet which reveals in direct and explicit terms the purpose of Special Branch's interest in police accountability groups, as well as some differing views as to the appropriateness of that interest. And sir, I'm going to ask that a document is brought up on screen. It's MPS-0748422. In case that's needed again, it's MPS-0748422. And in particular, page 5 of that document. So what you will see in the screen is a minute from Commander Wilson, and we see COSB on the bottom left. And it says this, in light of the Commissioner's and his senior officers' need to be kept informed of future developments, the Deputy Assistant Commissioner and I have discussed the Special Branch position about these monitoring groups. It is clear that the branch, in conjunction with the Security Service, is the only department capable of pursuing further inquiries. Just pausing there, sir, it is not clear whether the only department capable of pursuing further inquiries is an oblique reference to the SDS, although it certainly may be. But it continues, it is obvious that these groups are interested only in our faults and that a power base is being built from which attacks on the police can be launched. In these circumstances, it is right that our senior officers should be briefed in order that they can adequately respond to criticism. These views were expressed by the Commissioner at his conference with commanders, on 25th of March last. There is also a very important public order aspect. So we say it is of profound significance that the stated purpose of intelligence gathering was to enable senior officers to, quote, adequately respond to criticism, unquote. and that the view was expressed not only by Commander Wilson, but had been expressed by the Commissioner at his conference with commanders. The final reference to an important public order aspect is either a reference to an ancillary purpose, or more likely, it appears to us, a useful front for intelligence gathering that had no legitimacy or justification. It is also of note, sir, that others held a different view, and that document can be taken down. Thank you. So elsewhere in the minute sheet, we say that we can see that Detective Chief Superintendent Greenup considered it useful for officers joining interviews and discussions to receive a comprehensive briefing on the particular stance and other background information on the individuals involved in police accountability groups, but also that it was more usefully a task for A7 rather than special branch. I'm going to ask actually for that document to be brought back up, MPS-0748422 and page 9 of the document. That's MPS-0748422. So, sir, this is what we have on screen is a part of that same minute sheet, and it's a view expressed by Commander Operations Phelan. It says at paragraph 12, I recognise that a department sees a need to set up a unit to assist in answering criticism of the police. I agree with Chief Superintendent C that such a unit should not be in Special Branch. I concede that the unit might obtain information which would be of interest to Special Branch and that we might make use of the unit for our own purposes. Special Branch would of course pass to the unit any relevant material which was obtained from overt sources. However, I am quite convinced that the unit should restrict itself to gathering information from overt sources only. The gathering of covert intelligence should not be attempted, and in any case, such information cannot be used in the way envisaged. And that appears at least to display some unease as to the role of covert intelligence gathering on police accountability groups. Sir, it is not clear whether the same limitation was thought by Commander Phelan to apply to Special Branch, although DAC Hewitt followed the minute by observing that this subject is fraught with problems and we must take care not to stray beyond the new guidelines for Special Branch. Separately, the report came to the attention of Sir Hayden Phillips, a senior civil servant in the Home Office, who reported to Mr. Hewitt his very serious concern at the breadth and tone of and market for that report. Mr. Hewitt was said to have acknowledged that he has pushed to the limit a broader concept of public order intelligence. This is meaningless as expressed and dangerous in implication. So that's the same document at page 11. If we can turn to page 11. So sorry, it's actually in a separate document. So it's UCPI 5035096. That's UCPI 5035096. So, sir, again, this is correspondence from Sir Hayden Phillips in the Home Office. you'll see in the first paragraph referencing the lengthy GLC report, a reference to Sir Hayden Phillips having spoken to Mr. Hewitt of Special Branch about the very serious concern at the breadth and tone of and market for this report. And then in the second paragraph, the observation that in Sir Hayden Phillips' view, he did not think the response from Commander Hewitt on behalf of Special Branch stood up to examination, and he doubted whether Mr. Hewitt really did either. And Mr. Hewitt had acknowledged that he had pushed to the limit a broader concept of public order intelligence, and it was Sir Hayden Phillips's view that that was meaningless expressed and dangerous in implication, and that is something, sir, with which we would agree. Ultimately, it is evident from reading the rest of that communication, sir, that it was felt that the concerns expressed to Mr. Hewitt would be sufficient, and that no further intelligence gathering of the sort in the GLC report would be undertaken. But that clearly, sir, was naive and ignorant as to Special Branch's intense and long-standing interest in police accountability groups and justice campaigns. So that can be taken down. Thank you. Centrally, it is perfectly clear that Special Branch interest in police accountability groups generally and justice campaigns specifically was one of assisting the force respond to criticism and legal action, respectively. Although a 1983 document, it reflected an interest which had existed in the preceding years. And so in our written submissions, we give you references to intelligence gathered on justice campaigns, both before and after 1983. There is also no other credible explanation in the documents for the targeting of such groups by the SDS. Ultimately, there is nothing to suggest that this self-serving interest of Special Branch in police accountability groups was an aberration of early 1983. It was clearly an interest which existed both before and after. So I turn to the interest of Special Branch in the Blair Peach campaign in particular. So as is evident from the repeated reporting on Celia Stubbs and the Blair Peach campaign, the interest of Special Branch in police accountability groups certainly included the Blair Peach campaign for justice. The controversy surrounding Blair Peach's death would inevitably have been a concern to the Metropolitan Police and the Home Office. Indeed, Dr. Graham Smith, who has assisted with this submission, has unearthed from the National Archives a note of a discussion between the Prime Minister and the Home Office on the 25th of April 1979, in which the Prime Minister complained that the Southall incident had been the top story yet again on the BBC One News, and it was important to get it out of the headlines. The Home Secretary thought this press conference, the press conference of that day had contributed to that objective, albeit the Prime Minister felt that the fewer press conferences, the better. Similarly, Sir Charles Pollard, who was given evidence, the officer in charge of policing at Southall on the day in question, described it as a real disaster for A8 and the Metropolitan Police, before going on to state that the event was seared on his mind. He also noted in his statement that there would have been big meetings, quote unquote, with the Home Office and comments on the rarity of preparing a written report for the Home Office, as opposed to the routine post-demonstration reports prepared after other demonstrations. It is also of note, sir, that in forwarding the SDS annual report for 1979 and seeking approval for its continuance from the Home Office, it was reported by the Assistant Commissioner at New Scotland Yard in his letter of 7th of March 1980 that the focal point of so-called extremist activity had been the general election held in May 1979, and that the culmination of the virulent anti-fascist demonstrations was the death of the Anti-Nazi League supporter Blair Peach and the subsequent campaign against the police. It is of note that Blair Peach's death and the subsequent campaign was reported by Special Branch to be a focus of that year, and featured prominently in the report of the SDS activities to the Home Office. It is also striking, sir, that as we have already observed, the gathering of intelligence by undercover officers on the campaign lasted over such a lengthy period. So moving then to the use to which evidence gathered on the Blair-Peach campaign was put. We have nothing like a full answer as to the uses to which information was put, as the inquiry, as we have observed, has not sought disclosure, or at least complete disclosure of that from Special Branch. There are, however, some examples appearing within the disclosure of gathered intelligence being put to use. There is no example of any of the intelligence in respect of Celia Stubbs or the campaign being of any meaningful utility for any public order purpose. There are, however, examples of gathered intelligence being used to assist the police force in responding to the campaign's attempts at achieving justice and accountability. Could we have on the screen Doc 076? And this, sir, is a Special Branch document that was obtained by Celia Stubbs via a subject access request. It's dated 19th of June, 1979. So as you can see, the report is described as concerning those persons known to this branch, known to Special Branch, who have made written statements to police concerning the death of Blair-Peach during an anti-National Front demonstration at Southall on the 23rd of April of that year. And it references an appendix which shows a list of all the persons who have made statements and what is described as a brief resume of information concerning each individual held by Special Branch. The schedule itself is available, but is entirely redacted. So it is a collation, sir, of the key information held by Special Branch on all individuals giving evidence in respect of Blair-Peach's death. The document does not spell out why Special Branch was collating and reporting information it held on all of these individuals, but we say it is difficult to see any motivation other than that it was looking for opportunities to discredit accounts given of police brutality, which resulted in Blair-Peach's death. It certainly has nothing to do with public disorder and everything to do with the investigation into the death. So the second document that, again, I would like to be have brought up on screen, it's MPS 0733406. MPS-0733406. So this is another Special Branch memorandum. It's from April 1980. It records a meeting with the Deputy Assistant Commissioner of Operations of the Metropolitan Police regarding the Friends of Blair-Peach Committee. And you'll see, sir, that it observes that consideration is being given to applying for a High Court injunction to prohibit the further publication of the names of officers of the Special Patrol Group allegedly involved in Peach's murder. And if we look further down that page, the information is given that the committee was an umbrella organisation dominated by the SWP and ANL. The names of the leading figures are included, including Celia Stubbs. The address is given, as are some other details, including where leaflets were printed. So both of these documents are Special Branch documents, indicating that Special Branch information was used for the purpose of responding to that campaign. So we can't draw the direct line from SDS information to these special branch reports, to the use to which it was put. But it is perfectly evident, sir, from the many STS reports that you will have seen, that this is precisely the sort of information that the SDS was concerned with gathering, and we can see the use to which it was put. So moving then to how SDS targeting sought to serve the general interests of the Metropolitan Police. So that's set out from paragraphs 50. So that document can be taken down. Points about how SDS targeting sought to serve the general interests of the Metropolitan Police is set out from paragraphs 50 of our written submissions. I'm not going to take you through that in detail for reasons of time. But the central point, sir, is that as counsel to the inquiry has observed, the SDS did not operate in a vacuum. It was part of the Special Branch and Metropolitan Police machinery. As I have just taken you through, it is clear that the Special Branch was interested in police accountability groups and justice campaigns for the purpose of responding to them and protecting the Metropolitan Police from criticism. And it was that general interest, we say, that the SDS sought to serve. So I'm going to move then to our submission that reporting on the Blair-Peach campaign could not have been simply incidental to other objectives. It was suggested by the designated lawyers in the opening prior to part 1 that SDS personnel did not infiltrate or target justice campaigns, and that such campaigns were only referred to in SDS intelligence reports, if and to the extent that they came into contact with those who were being reported on. The suggestion appears to have been that any intelligence gathered was wholly incidental to some other objective or target. So we say that is so patently wrong. As above, as I've already set out, sir, despite having absolutely nothing to do with any public disorder, the SDS gathered information on the campaigns regarding Blair-Peach over at least 2 decades. If the primary purpose really was preventing public disorder, then targeting the Blair-Peach campaign was utterly farcical targeting. The reality is that it had nothing at all to do with public disorder. It was all to do with Special Branch's intense and enduring interest in police accountability groups and the specific campaign for justice in relation to Blair-Peach. We also know, sir, that there was specific targeting relating to the Blair-Peach campaign. For example, HN21 has given evidence that he was tasked to attend the funeral, although he also considered it highly unlikely that there would be any disorder there. So I now turn to address the submissions made in writing and orally yesterday by the designated lawyer in respect of Celia Stubbs and the Blair-Peach campaign. So the 7 paragraphs in writing of the designated lawyer's submission, paragraphs 4.51 to 4.57, represent the only attempt in the closing submissions of any core participant to seek to justify the targeting of justice campaigns. A single paragraph of those 7 is concerned specifically with intelligence gathered in respect of Celia Stubbs. So it is a sparse attempt at justification. The designated lawyer asserts in those submissions that there, quote, is no principle that the police cannot or must not concern themselves with justice campaigns, or in particular, anti-police campaigns, simply by reason of their status or objective. And further, that the police cannot, quote, abdicate responsibility for the maintenance of public order. That, sir, is a straw man. There is no suggestion that there is any need for an abdication of police responsibility when it comes to justice campaigns. Our submission has been that targeting a campaign for justice, such as the Friends of Blair Peach Committee, could never be lawfully justified unless there was some reason to consider the campaign was conspiring to perpetrate significant crime. The point here is that the Blair Peach campaign was not a criminal enterprise, nor was there any reason to suspect it might be. It did not conspire to cause public disorder. It was a campaign for justice pursuing lawful means, and obviously so. It remains a source of distress to Celia Stubbs that public disorder continues to be raised as a justification for spying on her. In respect of the Blair Peach campaign specifically, the designated lawyer makes two observations. The first is that the Friends of Blair Peach Committee is said to be connected with the Socialist Workers' Party and the Anti-Nazi League. There is no elaboration as to what is meant by that or why it is said to be significant or to justify intelligence gathering. Both Celia Stubbs and Blair Peach supported the SWP and the Anti-Nazi League, but that does nothing to justify the gathering of intelligence on the campaign for justice. The second observation made by the designated lawyer is that, and I quote, the committee staged a number of major public order events which needed to be policed and which the SDS needed to include in its reporting, unquote. The designated lawyer then adduced for the first time and via hyperlinks video footage of a march that took place in the aftermath of Blair Peach's death on 28th of April 1979 and of the funeral on the 13th of June 1979. So we do not know precisely the provenance of those videos. We are told by the designated lawyer that inquiries were made with the British Film Institute, who recently transferred old video reels of the Metropolitan Police into a digital format and made them available to the designated lawyer. They were described by Mr. Sanders King's counsel yesterday as a random and ad hoc collection, but they were, of course, a random and ad hoc collection as selected by the designated lawyer. So if there is a resource of videos that may be relevant, it surely would have been more appropriate for the inquiry to be made aware and invited to review and select them. One video is of the procession to the funeral of Blair Peach. It shows a woman in mourning being presented with flowers. As might have been obvious, that woman was Celia Stubbs. Until Friday just gone, Celia Stubbs had never seen that footage and did not know it existed. So for individuals directly affected by the subject of this inquiry, closing submissions can be an emotional and distressing time. To be presented without warning with deeply personal footage came as something of a shock to Celia Stubbs, and it is unfortunate that it was produced in that way. In correspondence, the designated lawyer has expressed that it was sorry if Celia Stubbs was distressed by the video, but we would invite a more fulsome apology. For your purposes, sir, what are the relevance of these videos? Firstly, the fact that there was a march and a funeral procession in April and June 1979, respectively, does nothing to justify intelligence gathering that continued into the 1990s. Second, whilst they were undoubtedly public order events that required policing, there is no evidence at all that undercover policing served any value in policing them. Neither is there any explanation as to why undercover policing may have been necessary or even helpful in doing so. Third, sir, they were entirely peaceful events. The level of public concern at that time as to the events of Southall and the death of Blair Peach was significant. The atmosphere, sir, was febrile. But notwithstanding all of that, the march and the funeral procession were peaceful. That is in part because the Blair Peach campaign was always a peaceful campaign pursuing justice by lawful and peaceful means. So we consider it important for the public record that at least part of the videos are played, and I'm going to ask that footage of the funeral procession is brought up on screen. It is Doc 100. It's about 10 minutes in length, so I'm clearly not going to ask for all of it to be paid, sir, but the first minute or so. If it could be brought back to the beginning, that would be helpful. So there, sir, you can see Celia Stubbs being presented with flowers of condolence. And shortly we will see the start of the procession. Could we move forward to around 3:30 and we'll see more of the procession itself? So you see there the flag of the London Teachers Association, and Blair Peach was, of course, a teacher. And you'll see ordinary, generally suited members of the public, no doubt including some fellow teachers of Blair Peach. So as I have said, it was an entirely peaceful event. It was certainly a large event, and in the broadest sense, a public order event that was attended by uniformed officers. But uniformed officers were present peaceably, and there was no need to also have covert officers posing duplicitously as persons being there in mourning. So if that and the equally peaceful march of 28th of April 1979 represents the high point of the justification for 2 decades of intelligence gathering on Celia Stubbs and the Blair Peach campaign, it reveals, frankly, how vacuous the attempted justification is. And that video can be taken down. Thank you. So at paragraphs 59 and onwards of our written submission, we describe the effect of the undercover policing targeted at Celia Stubbs and the Friends of Blair Peach Committee. We say, in summary, sir, that there must be a negative impact on public confidence in coming to learn that justice campaigns were targeted by undercover officers. And at paragraph 62, sir, of our written submission, we record what Celia Stubbs said of first receiving the disclosure. It was extremely upsetting to see this material and to see how the police treated our actions and events that were law-abiding and were simply trying to get to the truth of what happened. I was surprised by how upset and angry I felt. It seems that they lost all sense of the fact that Blair had been killed by police officers and that our distress about this was criminalised. It is hard to describe how violating this is. So it's part of your terms of reference to examine the effect upon individuals, and that should obviously include the impact as described upon Celia Stubbs. So I turn finally to whether undercover policing of Celia Stubbs and the Blair Peach campaign was justified and lawful, and I have just a couple of minutes left, sir. The only suggested justification for the SDS from its inception to this inquiry is that it was useful for policing public disorder. That has also been the only suggested justification in respect of targeting Celia Stubbs and the campaign. 3 submissions are made in respect of the utility of the SDS to public order policing and the issue of justification. First, the evidence suggests that in fact its utility was either negligible or at its highest modest, not least as a great deal of information could be obtained from open sources. And so we note the observations you made yesterday as to the limited extent to which SDS intelligence gathering actually contributed meaningfully to any available threat assessment. Others in the general group will make more detailed submissions on that point, sir. It is evident in respect of both Red Lion Square and Southall that information in advance was available to the Metropolitan Police. In respect of Southall in particular, the Special Branch report of 23rd of April 1979, the day of the march, gives not a hint of anything useful having come from the SDS. And we believe, sir, that that observation chimes with yours of yesterday. Of course, obtaining information overtly and in collaboration with the community and the groups protesting would ultimately be far more consistent with the approach of policing by consent. And in our written submission, sir, we give you submissions that were made by the Blair Peach campaign to that effect in that period of time. Second, sir, we say that there must at least be a suspicion that the SDS had, in fact, a harmful role in policing disorder because it frustrated or at least failed to comply with processes seeking truth and accountability when public order policing went wrong. And there are, again, parallels between Red Lion Square and Southall. So there's more detail in our written closing, but the short point is this: in respect of both Red Lion Square and Southall, where public order policing clearly went wrong, SDS reports appear to have gone missing for reasons which there has been no cogent explanation. There must also be concern, sir, that important information held by the SDS and Special Branch more generally was concealed from both the Scarman inquiry and the inquest into Blair Peach's death. So, for example, HN 301's account of being punched for no reason at Red Lion Square was presumably not provided to Lord Scarman, given Lord Scarman's finding. And similarly, in respect of Blair Peach's death, HN 41's account of being smuggled into Scotland Yard to give a statement to the murder squad indicates that there was some awareness of the SDS presence, but that knowledge and presence does not appear to have been revealed at the inquest. Third, sir, and in a sense more fundamentally for the purposes of your terms of reference, the targeting of and intelligence gathering in relation to Celia Stubbs was not motivated by or concerned with public disorder policing at all. It was, as we have said, motivated by assisting the police in protecting itself from criticism. If that is accepted for the reasons we have set out, then it follows that it was unjustified. No core participant has suggested that utilising undercover officers for the purposes of protecting the police from criticism can possibly be justified. That really, sir, is the short answer, we say, to the question of justification. So in general terms, there are two limbs to the function and responsibilities of the police: the positive obligation to act so as to preserve the peace by enforcing the law of the land, and the negative obligation to refrain from acting so as to unjustifiably interfere with the rights of citizens. The SDS generally, and in relation to Celia Stubbs and the Blair Peach campaign, fundamentally failed in both respects. By engaging in decades of covert intelligence gathering, it interfered with her right to peacefully pursue justice, and it also failed to pursue, or at least sought to frustrate, the positive obligation to act so as to enforce the law. So I conclude with this remark. A public body whose actions are examined in an inquiry need not necessarily await factual findings to recognise wrongdoing. That is recognised to a point by the Metropolitan Police, which has made and repeated apologies in respect of sexual relationships, deceased children's identities, the disproportionate or unnecessary recording of personal information, and use of inappropriate language, and quite rightly so. However, sir, in the 94-page closing submission of the Metropolitan Police, there is a complete silence in respect of the intelligence gathered in respect of Celia Stubbs and the Blair Peach campaign, and also the ways in which views were expressed about Celia Stubbs by Special Branch. The Metropolitan Police certainly does not seek to justify it, but neither does it acknowledge that it was wrong, and nor does it acknowledge the impact upon Celia Stubbs. We are unclear as to why, but that is something to which the Metropolitan Police may give consideration. For our part, sir, having reviewed the evidence disclosed over the past 3 years, we say it is unfortunate that no apology has been offered to Celia Stubbs by the Metropolitan Police, in relation to their actions towards her over a period of 2 decades. So with that, and with an apology for running slightly over, unless I can assist further.
Thank you. No apology is required. I hope that your last remarks are reflected upon and responded to, but it will not be by me.
Understood, sir. Thank you.
Thank you.